Ready to proceed?
Yes, Your Honor.
All right, we have everybody present. This is Peter from IT. He's going to explain to the jurors the jury card. And then Carl, once he's done, can we have someone take Peter into the jury room to drop the card off and then take him back out and lock the door afterwards?
Yeah.
Okay. So we'll do that. While somebody's taking Peter into the jury room, I'm going to go ahead and start the jury instructions with the jurors, okay? All right, let's bring the jurors in. All right, everybody may be seated. Welcome back, members of the jury. This is Peter. He works in the building here with our IT department. He's going to explain what we affectionately call the jury card. Peter?
This jury card, we'll put it in the jury deliberation room for you, should you need to review any of the evidence you've seen before. It's set up so that it does not have any network connectivity, but it does have applications which you can use to play video evidence on it. There's a CD player mounted in here for you to access, and a DVD player up here should you need it. When you see it in there, it'll boot up the screen showing the sealed 12th circuit here. The applications are listed down here. You'll have a mouse and a keyboard should you need to advance or rewind video and that sort of thing. If you run into any technical issues with it, Judge Krug will let you know how to reach out to us, and we'll be down to assist you.
Where's the mouse? There it is. Okay, and the keyboard?
Right here.
Right there. Okay, I couldn't see. Okay. All right, Deputy, if you can please take Peter and we'll have that plugged in the jury room. Okay?
1 second. Turn it up.
It's not okay just to unplug it right away?
Rather not.
Folks, what's going to be next for us is I'm going to read to you the jury instructions. That was that white packet you have in front of you. So you can go ahead and turn to that. As soon as we get Peter out, we'll start with those. Give me 1 minute. All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charges. Dima Tower, the defendant in this case, has been accused of the crimes of count 1, murder in the first degree, victim Jennifer Tower. Count 2, murder in the first degree, victim Robbie Tower. Count 3, fleeing to elude a law enforcement officer, lights and sirens activated. In this case, Dima Tower is accused of 2 counts of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Jennifer Tower was killed by Dima Tower, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. If you find Robbie Tower was killed by Dima Tower, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Dima Tower may be found guilty of murder in the first degree of victims Jennifer Tower and Robbie Tower, or any lesser included crime. Count 1, murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was a premeditated killing of Jennifer Tower. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2, murder in the first degree. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was a premeditated killing of Robbie Tower. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 3, fleeing to elude a law enforcement with siren and lights activated. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following 3 elements beyond a reasonable doubt. 1, Dima Tower was operating a vehicle upon a street or highway in Florida. And 2, Dima Tower, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. And 3, the law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. Street or highway means the entire width between boundary lines of every way or place of whatever nature, when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except personal delivery devices, mobile carriers, and devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree, manslaughter. To prove the crime of second-degree murder as a lesser crime of first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was an unlawful killing of Jennifer Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter as a lesser crime of first-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, Dima Tower intentionally committed an act or acts that caused the death of Jennifer Tower. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. You'll see I'm now moving on to those same lesser includeds for count 2. To prove the crime of second-degree murder as a lesser crime of first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was an unlawful killing of Robbie Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, a lesser crime of first-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, Dima Tower intentionally committed an act or acts that caused the death of Robbie Tower. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a mere negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused the death. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed, and that the defendant is the person who committed the crimes. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted, as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you would apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Statements claimed to have been made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to 1, whether when the defendant made the statements he had been threatened in order to get him to make statements, and 2, whether anyone had promised him anything in order to get him to make the statements. If you conclude the defendant made the out-of-court statements, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged in the charging document or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each of the crimes charged. The verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It reads as follows. You don't have the verdict form. We only have one. I have it here, and I know we're a bit distant, so you can't see it, but it's when you get it, you'll see it's titled State of Florida v. Dima Tower, and as a case number, it's titled Verdict. It gives you instructions to check one as to count one, check only one, it says, as to count 1, 2, and 3, and a place for it to be dated and signed by the foreperson. Emily, I'll give that to you. This last jury instruction in your packet, you can put that aside. I'm going to read that to you after the closing arguments. Members of the jury, the attorneys will now present their final arguments to you. Please remember that what the attorneys say is not the evidence nor your instructions on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Each side will have an equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, are you ready to proceed?
Yes.
You may do so when you're ready.
Thank you, Your Honor. Good morning, ladies and gentlemen. Back on Monday, which probably seems like an eternity to you by now, the judge talked about the two things that the state has to do in its case. It has to prove beyond a reasonable doubt that a crime or crimes were committed in the murders of Robbie and Jennifer Tower and the fleeing to elude. And that the defendant who sits here in the courtroom before you, Dima Tower, is the person who committed those crimes. I think that those things have been proven to you fully during this trial. The only thing that we should talk about today, and that's important for you to focus on, is the defendant's intention. Because in opening statements, defense counsel told you that he was going to argue for a lesser included crime, a crime of manslaughter. So let's think about the instructions that you have in front of you and what they say and why this is not manslaughter and it's not second-degree murder, and it completely and fully meets all the elements of first-degree premeditated murder. Your Honor, I'm having a problem, and I don't know why this isn't working correctly.
All right, let's take a short break. We'll bring IT to try to solve that, okay? Please leave your notepads face down, writing implements on top. Don't discuss anything related to your jury service, okay? Emily, can you call IT to come down? You ready? Okay. Can you radio Carl that we're ready to bring the jurors back in when they are? Great, everybody may be seated.
Thank you, ladies and gentlemen. You've probably worn out that carpet by now, going back and forth. But let's continue where I left off. So what we have to focus on are the instructions for law and the evidence in this case. And you have those instructions in front of you, but I have the elements of first-degree murder up on the screen. So to prove the crime of first-degree premeditated murder, the charge that the state has laid against the defendant, actually 2 counts, but I incorporated both Jennifer and Robbie Tower into this instruction. To prove the crime of first-degree murder, the state has to prove the following 3 elements beyond a reasonable doubt. Jennifer and Robbie Tower are dead. There's no question about that. It's uncontested. Their deaths were caused by the criminal acts of Dima Tower. Again, uncontested. Not only do we have all the physical evidence in this case, the knives, the fact that the defendant was covered in blood, the fact that he fled, but we also have his own words. He told the detectives who interviewed him that he killed his parents. So we know that their deaths were caused by Dima Tower, and obviously they were criminal acts because he stabbed them to death. That's a crime. Finally, there was a premeditated killing of Jennifer Tower and Robbie Tower. And how do we know that? We know that because the defendant told us so himself, over and over and over. Yesterday afternoon, on the stand, he told you that himself. Repeatedly to the detectives, and then again, right here in the courtroom where you're sitting today. So let's talk a little bit about premeditation and the definition. Now, back on Monday, I was asking you a lot of questions about what factors should you think about when we're talking about premeditation, and you probably thought, what is this woman talking about? Because you didn't have the facts. You didn't know what went on in this particular case. And I was asking you questions about what would a person do before committing a premeditated act if you didn't know what was going on in their mind, but you had to look at their actions and determine what was premeditation. We talked about what would a person do while the crime was being committed that would signal premeditation. And we talked about what would a person do after the crime was committed to signal premeditation. And let's think about what we learned in the last 3 days. What did the defendant do before he committed this crime? He chose his weapon from the knife block in the kitchen, and he took it into the bedroom. He armed himself before the encounter with his parents. All of that leaves plenty of time for reflection, for reflective thought. And we also talked about if there are prior difficulties between the parties, does that lend itself to thinking about premeditation? If someone is already angry, and as the defendant said, boiling with rage, does that lend itself to premeditation? Is that one of the factors you should consider? And I would suggest that it is. And then what did the defendant do at the time he was committing the crime, when he was stabbing his parents by a conservative estimate 140 times? We talked about, do the nature of the wounds that are being inflicted, do they show that the defendant had a conscious intent to kill? Well, we know the kind of wounds that he inflicted on the tracheas of both parents and on the multiple stab wounds, especially to the face, the head, the back of the neck, especially the throat, the carotid arteries, and the jugular veins, the most vulnerable, tender part of any human being. We also talked about, is it important to consider the number of wounds inflicted? And we know that there were, again, over 140 wounds, 79 to Robbie and, 79 to Jennifer and more than 68 to Robbie. What else at the time that the crime is being committed signals that this was premeditated? What about the fact that when he lost the first knife, he went back into the kitchen and got himself another knife so that he could, as he said, finish what he started? Because he started it deliberately and consciously. He wanted to finish that job. And so he armed himself with another weapon. What else did he do during the crime that shows premeditation? After he killed his father, he walked outdoors, and yesterday he told us that he had the knife in his hand when he went outside. And he led his mother back into the death scene and sat her on the couch and, in his own words, delivered a manifesto. He said it was a monologue. And all the time she's sitting there and he is planning to kill her. There is no other way to think about it. What else did we talk about during jury selection? We talked about what might signal premeditation after the crime is committed. We know that the defendant washed the second knife and placed it back in the knife block because it was collected as evidence, and we can actually see the little bit of blood in a close-up photo. It was also sent to the Florida Department of Law Enforcement, and Ms. Webster told you that there was presumptive blood on both weapons. After he took the knife and placed it back in the knife block after he gave it a cursory wash, he fled from the police. You saw 30 long minutes. It was probably boring, but I thought it was important to impress upon you just how long it took for the police to apprehend the defendant. How long he consciously fled from the police and showed a consciousness of guilt because he knew what he did was wrong. And we know that finally, when he was apprehended, he gave a full admission to consciously deciding to kill. That's premeditation all day long. So let's look at the instructions. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law doesn't fix the exact period of time that must pass between forming the premeditated intent to kill and the actual killing. But the period of time has to be long enough to allow reflection, long enough for the mind to come up with the idea, the plan, the decision, whatever you want to call it. Long enough to allow reflection by the defendant. And it has to be formed before the killing actually takes place. The question of premeditation is a question for you. It's a question that you have to answer based upon what you heard these last 3 days in the courtroom and the evidence that you've seen. And only you can decide if this was a premeditated act. It's sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused during the killing convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. let's talk about why this is not manslaughter and why this is certainly not second-degree murder. Let's start with second-degree murder because that's the first of the lesser includeds. That comes right after first-degree murder and is then followed by manslaughter. And if you want to follow along with me with the jury instructions, you have them before you. If not, you can just listen to what I have to say. Second-degree murder has to be proven by the state beyond a reasonable doubt, and it has to prove the three following elements. Jennifer and Robbie Tower are dead. Yes, we know that. The death was caused by the criminal act of Dima Tower, their adopted child. There was an unlawful killing of Jennifer and Robbie Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Is that what happened? Of course it is. It goes on to say that an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous, it goes on to define, to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. 2, the act is done from ill will, hatred, spite, or evil intent. And 3, the act or actions are of such a nature that they indicate an indifference to human life. All of those are true. That's exactly what Dima Tower did. But in order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. That is what's missing from second-degree murder. Dima Tower had every intent to cause the death of both Robbie and Jennifer Tower. He told you so himself. Why isn't this manslaughter? To prove the crime of manslaughter, the jury instructions tell you, the state has to prove the following 2 elements beyond a reasonable doubt. First, Jennifer and Robbie Tower are dead. And second, Dima Tower intentionally committed an act or acts that caused the death of Jennifer Tower and Robbie Tower. What's missing? Premeditation. The jury instruction goes on to say that in order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, excusable, or which caused death. But we know from the defendant's own mouth that he had every intention to cause death. He told us so over and over and over again. So the lesser includeds are statutorily mandated to accompany the jury instructions on first-degree murder. But they do not rise, they don't even come close to describing or meeting the elements of what Dima Tower did to his parents on August 31st, 2023, when he sat in that car and thought about killing them, walked into his house, went into his bedroom, came out, grabbed the knife out of the kitchen, and walked into the bedroom and started stabbing his father. Because this is a clear-cut case of first-degree murder. So he talked to detectives on September 1st of 2023, and Detective St. Jean and Detective Chippendale asked him a number of questions. What did you think about last night? I don't like the situation. I don't like the people I'm with. So I'm just gonna kill them. That's what he thought about before he killed his parents. That was his plan. You don't need a diagram, you don't need a journal with your thoughts written down, you don't need a flow chart, you don't need a bullet point list to premeditate the killing of your parents. All it takes is long enough time to reflect, to engage in reflective thought. And that's exactly what he did. I don't like the situation, I don't like the people I'm with, so I'm just gonna kill him. Did you guys talk at all? And here, I think Detective Chippendale is referring to what happened when the defendant brought his mom back in from outside when she was trying to alert the neighbor and try to get some help. So the detectives asked, did you guys talk at all? Yeah, the defendant responded. I tried to talk to her. How did that conversation go? It was a monologue. So did you stab her already at that point? After I finished what I had to say. He's giving a monologue, talking to his mother in the house. Plenty of time for reflective thought. Again, during that interview that you watched, and I urge you, ladies and gentlemen, to watch it again. You'll have an opportunity to take the evidence, most of the evidence back with you, and you can listen to that videotaped and audio tape recording. It's available for you. So last night, you're sitting in your car, and you just came up with this, that you're gonna do something now. Defendant said, no, it came before that. Detective says, after work? No, it was before that. I had those thoughts before yesterday. What, days, months? No, like recently. Reflective thought. Later on in the conversation, the detectives ask, was last night the first time you actually thought about killing your parents? No. And yesterday, the last question that I asked, when you were sitting in your car on August 31st, did you decide to kill your parents before you walked into the house? Yes.
What is the location of the emergency?
Listen, it's not such an emergency anymore right now, but we live at 1200 Malachute Road in Northport. And I was trying to reach Northport police, and it keeps sending me back to this.
Okay, should we get a police issue going on?
No, I was upstairs in bed, and my daughter was sleeping downstairs, and someone screamed, and banged on our door and rang the doorbell, screaming, I need help, I need help. Took me a second to register what was going on, and we were trying to find, Mark upstairs before we opened the door, and the person's gone.
Okay, let's actually have a Northport so they can check the area. Let me connect you, please.
Okay, thank you.
911, what is the
And this is what law enforcement found when they got to Jonna Walton's house. A blood trail leading up to her home, and at her door, more blood dripping while she rang the doorbell and screamed for help. And as she was out there, the defendant wanted to finish what he started, so he led her back in the house. And then, after he finished what he started, he came outside covered, according to Officer Regakis, with blood. And he just nonchalantly got in his car and drove away, covered with his parents' blood. He led the police on a chase for about a half an hour, even at one point endangering other people in the community by going into the northbound lane. And finally, when Sarasota County disabled his car, the stop sticks, he ran into the woods. And we had Officer Regakis get on the stand and show you, trace out for you, the flight path of the defendant from way down in the southeastern corner of Northport city environs, all the way to I-75, south on I-75, and then he backtracked and drove all the way up to almost the very end of what this map shows in the upper left-hand corner, where he abandoned his car and fled into the woods. And this is what the crime scene and the detectives found at 1240 Mallicote Road. This is the carnage inside the house. Blood everywhere, on the door, in the foyer, on the furniture, on the walls, on Dima Tower's parents. And where this crime started, in the bedroom where Mr. Tower was sound asleep next to his wife when the defendant attacked them while they were sleeping in their bed. And you can see the signs of struggle. Looks like Robbie Tower put up quite a fight as best as he could. You can see that there was a brief altercation over on that north wall, and again on the wall leading into the living room. Blood everywhere, but the defendant was determined to finish what he started. Even when he lost the first knife, he was determined to finish what he started. So he goes into the kitchen and grabs another knife, and then washes up afterwards. And this is a work product of Dima Tower. This is what he did to his father and to his mother because he didn't like them as people. You also heard testimony that the defendant was finally seen early the following morning after he had been at large for about 9 hours. He was captured on video at the Shell station around about 7:30 in the morning. He actually was blasé enough to walk into the Shell station and buy a bottle of tea. And finally, he was arrested shortly thereafter, around about 8 o'clock, when the Venice Police Department apprehended him, still at the Shell station. And this is what the defendant did to his mother. And I have not put up all the autopsy photos. I think you've seen enough autopsy photos and bloodshed, but this is what he did to his mother after he led her back in the house. Stabbed her multiple times in the face, the throat, and the back. And his father, mutilated to the point where Dr. Vega was able to count 6 separate and distinct perforations, incisions, whatever you want to call them, into Robbie Tower's trachea, his larynx. And you heard the testimony of Dr. Vega yesterday, who told you that the cause of death for Jennifer Tower was perforations of multiple small and large blood vessels, including her carotid artery and jugular vein. Same with Robbie Tower, perforations of multiple small and large vessels, including the carotid and subclavian arteries, due to multiple stab wounds. And Dr. Vega told you about the function of the carotid arteries and the jugular veins, how those are the major vessels that take the blood to the head and back down to the body. And that's where the defendant attacked his parents, in the most vulnerable, fragile places in the human body. Ladies and gentlemen, I'm going to ask you to think about the jury instructions and what you heard on Monday about sympathy. You saw the defendant sobbing here in the courtroom. We had to actually take a break. I think it was on Wednesday during the defense's opening statement. And then again yesterday when the defendant took the stand. He put on quite a display of emotion.
Overruled. Let's move on from this, okay?
He put on quite a display of emotion. Hold him accountable for what he did. You may not have sympathy enter into your deliberations. Your job is to look at the evidence and see if the evidence comports with the law of first-degree murder. You may not have any sympathy for Robbie or Jennifer Tower or the defendant. And that's hard to ask human beings. And you may even have sympathy for all 3 of those people. But they cannot influence your decision. That cannot influence your decision. You have to compartmentalize that sympathy if you have any. Because the law says that you must judge the defendant on the evidence and the law. Hold him accountable for what he did, ladies and gentlemen. Thank you.
Vince, when you're ready.
Like we talked about at the beginning of this case, Mr. Tower's words still hold truth. It has a lot to do with everything that I've been through and everything that I've seen. And you've heard a lot of evidence in this case, and frankly, a lot of it was not disputed. The facts and circumstances of the tragic events of August the 31st of 2023 are not materially in dispute. Robbie Tower is deceased. Jennifer Tower is deceased. Those things occurred because of acts by Dima Tower. That is not in dispute. What is in dispute is whether or not Dima Tower had the rational, conscious intent to commit the homicides prior to them occurring. That is what is in dispute in this case, and that is what we have been asking you to focus on and not get sidetracked into different areas. The judge has instructed you that you have to presume Mr. Tower to be innocent before you start. We kind of dialed that back a little bit and said, look, before we even start this trial, I want to make sure that we're clear about what we're asking of you. And what we're asking of you is to make a decision about one simple thing. And it may not seem that simple, and it may seem very complicated to get inside the head of somebody else. And it is. It's complicated. The state has the burden of proving these crimes beyond and to the exclusion of every reasonable doubt. I know the state will say that most of what we've been talking about is trying to invoke sympathy for Mr. Tower. That is not the case. It is important, if you're making a decision about somebody's state of mind, that you are exposed to them so that you can make an informed decision. There's a lot of talk in the jury instructions about people of ordinary judgment making decisions. And what the judge has instructed you is that it's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should be relied on in considering your verdict. We talked during jury selection about the fact that you don't leave your personal life experiences at the door. You bring those in because they form your common sense. And you can make the determination as to whether or not it's significant that Mr. Tower couldn't look me in the eye, couldn't look the state attorney in the eye, couldn't look the detectives in the eye at any point in time. That is something that is common for certain people. And when we're talking about individualized consciousness of guilt, every individual reflects differently. Every individual thinks differently. So if we're talking about the fixed time for reflective thought, it's important to consider all of the factors as to whether or not Mr. Tower had sufficient time for him to make reflective thought. Given his history, whether or not the killing was done after consciously deciding to do it. I would submit that Mr. Tower doesn't have the ability.
I'm going to object to this, and may we approach,
No, I'm going to sustain the objection.
Okay.
Sustain the objection.
thank you.
I'll disregard the last statement by defense counsel.
The question of premeditation is a question of fact to be determined by you from the evidence. And the judge instructs you, again, use your common sense. Think about what evidence is reliable and what evidence isn't reliable. As Mr. Tower indicated, When there was discussions with law enforcement, he was concerned that there were misstatements, misunderstandings, which would be something you would understand from somebody who was in foster care in a foreign country, who didn't know the language before he got here, who learned the language himself by small talk, who was obviously awkward and uncomfortable. You can make a determination as far as all of those things, as to what weight you put on each piece of evidence and what weight you assign. Because like we talked about from the beginning, each of you individually has a verdict. And collectively, as a jury, you make a decision. But it is important for each and every one of you to have your voices heard. It's important that you take time to deliberate and make a determination as far as what culpability Mr. Tower has. I would suggest to you that the evidence presented leads to a manslaughter conviction. And we would ask that you come back with that verdict. Thank you.
State rebuttal when you're ready.
Defense counsel argued that defendant told you yesterday, and he did, that this has a lot to do with everything I've been through and everything I've seen. You've heard no evidence, zero evidence of the defendant and what he saw and what he's been through. You are not.
Burden shifting?
I'll overrule the objection. I'll just remind everybody, there's no obligation or burden on the defense to do anything. You may continue.
The defense has no burden. But when you hear arguments that defy logic, you can reject the arguments by the defense. The defendant doesn't have to prove anything in this case, but he did. He proved everything in this case when he took that stand yesterday, and he said, I was sitting in the car thinking about it before I went into the house. I thought about killing my parents before I went into the house. So again, does the defense have to prove anything? No. Is it my burden? Yes. And I urge you to hold the state to its burden. But you have heard no evidence, absolutely no evidence, about what the defendant has seen and what the defendant has been through. And that is not burden shifting. That is simply a fact. The defendant described this as rage, but not rage that developed suddenly from a sudden event, some altercation with his parents, something that would make an ordinary, reasonable person lose self-control. This wasn't something sudden that happened that made Dima Tower lose his normal self-control and go in there and stab his parents. As I said earlier, his parents were fast asleep in their bed. They posed absolutely no danger to him. They did nothing to upset him or provoke his rage that night. I don't know where his rage was fostered, and neither do you. But he had rage for his parents when he was sitting out in that car, and he acted on that rage. This was not manslaughter. This was not a crime of passion. He sat out in his car and thought about it. And again, you're going to hear instructions about speculation. They're in your jury instructions. On Monday night, you took an oath to well and truly try this case based on the law and based on the facts, not on speculation. In fact, the jury instructions forbid you to speculate about the defendant's past or what he's seen or what he went through when his mother died. That's pure speculation, and you may not do that. Do not let yourself be persuaded because the defendant tried to, and was prevented, correctly so, from talking about his past, because that is not why we're here. We're here because the defendant killed his parents. The law doesn't change for people to fit their situations. Whether you're an executive of Coca-Cola or whether you're a kid from a bad neighborhood, whether you graduated from Northport High School or you graduated from Harvard, the law is the same for every single person. And what he went through when he was a kid has nothing to do with this crime that he committed. Don't be persuaded that because the defendant had a horrible childhood and he ended up in an orphanage, that he's somehow justified in doing what he did. Those photographs say everything. There is no justification for that. I'm asking you to think about the facts and think about the law, and only that, because there is no room for sympathy or speculation in your job. I'm asking you to hold the defendant accountable for what he did. I'm asking you to find him guilty of killing Robbie Tower and Jennifer Tower after premeditation. I'm asking you to hold him guilty of first-degree murder on both counts, and also for fleeing to elude law enforcement officer with lights and siren. I thank you for your patience and your attention.
And that concludes the closing arguments. Folks, as you might know, I think we talked about this at jury selection. We chose to have two alternates because we were going for the whole week. If someone got sick, we wouldn't have them fill in. Do you folks remember your numbers from day one? Remember you had a paddle in your hand? I'm going to try to see if we can identify our alternates by number. They were number 45, initials SN, is that right? Okay. And juror number 50, JP. Where are you? Do you folks have any personal belongings back in the jury room? Yes? While I'm going over this last instruction, why don't you go with Carl, the bailiff, and gather your personal belongings. When you're done, Carl, give me about maybe a minute or two. We'll bring you back in. You can just come over to the side. You've spent a whole week with these folks. You can say bye to them as they're walking out in transition. I'm going to speak to you just for a bit before I send you folks home, okay, the alternates, okay? Everybody can remain seated while the alternates head out with Carl. For the rest of you, comprise our jury, so you can turn to that last jury instruction in your packet. I'm going to read that to you. In just a moment, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until that juror returns. You are not to communicate with any person outside the jury about the case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, or laptops, or other electronic devices in the jury room. The rules do not allow you to keep those or bring those into the jury room. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the bailiff. These devices will be safeguarded by the bailiff while you deliberate. I think what Carl will do is he'll put a cart outside your jury room. If you want to make a call to a loved one, let them know you're well. Turn your phone to silent or off. That includes Apple Watches, electronic watches, iPads, any electronics. If you can turn those to off or silent, just put them on the cart outside the jury room, okay? If you need to communicate with me for any reason, send a note through the bailiff. If you have voted, do not disclose the vote in the note. If you have a question, I will talk with the attorneys here in court before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. A, some of these exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see any of these other exhibits, please request that in writing. Both apply in this case. What we decided is we're not going to send any of the knives back to you in the jury room. There was a butcher block, you may recall, with some knives and then 2 other knives. You're entitled to see those if you wish. So that would be a note by a foreperson signed saying would like to see the knives, for example. What we'd do in that case, I'd talk about it with the attorneys. We could either have a bailiff just bring them into the jury room, have you have access to those for a few minutes and then collect them, or we can bring you back into the courtroom and have a bailiff walk in front of you with those as well, okay? But other than the knives, all other evidence will go back with you. Again, you have the jury cart back there if you want to view or watch any evidence that's in the form of electronics. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. All right, folks, at this time, if you can take your writing implement, your notepads, and your jury instructions, and head on out with Carl, okay? To my alternates, go ahead and just move a little bit so the other jurors can go by. be at recess until we have a question or verdict. Please leave your cell phone with the clerk. Please stay within 15 or so minutes so that we can all get back into the courtroom. Folks in the audience, we're not going to individually, of course, call any of you. If you want to be present, leave your number with the attorneys, and they'll assist you in letting you know when we're back in court. Okay? All right, we'll be adjourned until we have a question or verdict. Folks, thank you. You don't need to tell me if you're upset or happy, but I don't understand why.
Cannot influence your decision. Compartmentalize that sympathy if you have any. Because the law says that you must judge the defendant on the evidence and the law. Hold him accountable for what he did, ladies and gentlemen. Thank you.
State's closed, at least the first portion. Of course, they have the rebuttal. Nicole DeBoard is a criminal defense attorney watching along with us. Your thoughts on this close and the case overall?
I think that the prosecutor did a great job in terms of trying to keep her tone very calm. The facts of this case are just absolutely heartbreaking and grisly and horrific. And it does not generally serve prosecution team well to continue raising emotion through their own tone in that kind of circumstance. It can actually inoculate the jury against such serious facts when they do that. So she's taken, in my opinion, the right tack. I'm not so sure she needs to worry necessarily so much about sympathy overriding decisions about guilt. The facts in this case seem patently clear. I think the defense has an extremely difficult job ahead in terms of closing arguments.
Oh yeah, I mean before he took the stand yesterday, you could think, I hope maybe a juror would have some sympathy, empathy for him because he was crying. He seemed really upset. You see the clock just popped up in real time. The jury has just gotten the case, but boy. Unless there is an angry adopted Ukrainian on this jury, I can't see any connection between a juror and this man, a young man, after his display on the stand yesterday. So what should we expect here from the defense? They're up next. How do you, with a straight face, really push for manslaughter, which is what they're after?
I think that they really have to do what the prosecution actually ended her case with, which is to say, take the sort of emotion out of your decision making and look at the actual facts. Some of his behaviors are certainly highly unusual considering what happened, what he just did. And, the calm walking to the vehicle, the calm going in and out of the gas station. There is some evidence for the defense to discuss with these jurors about his inability or just the fact that he didn't process this information in the way that we would expect somebody to process this information. So he did not have, and certainly this is what the defense may argue, not that I'm agreeing with these facts, but that he may not have had the requisite intent to reach the elements of the prosecution's case. And these odd behaviors that you can see for yourselves, jurors, on the heels of this absolutely horrific crime, just don't add up to the crime that he's been charged with, and in fact, maybe something lesser.
Yeah. All right, well, let's get a break and we'll see. what the defense does. When we come back, we'll watch the defense closing argument. He's got a great lawyer. Yeah, we saw his opening. He was fantastic, but he was gutted likely by the defendant making that choice to take the stand. Plus, we'll get an update on the love triangle beheading trial for former porn star Devin Michaels. We're in verdict watch on 2 separate cases. It's Friday. We'll get you into the Dima Tower closings and see what the defense is going to say in just a minute. But first, we want to get an update in Vegas, the love triangle beheading trial for Devin Michaels. Oof, what a case. The defense case begins later today. In studio on this Friday, Court TV crime and justice correspondent Matt Johnson. All right, we're the state's done, they did a lot. Now it's time for the defense.
Yeah, now it's time for the defense, and really, it could come down to today. So today is day 7 of the trial playing out there in Sin City, Las Vegas, Nevada. Yesterday, the state rested its case in chief after calling 22 witnesses over 6 days. On Thursday, the state called several more witnesses from family services, talking about a possible motive here, talking about custody issues between the victim and this defendant that you're looking at right there. Then the defendant's interview with police after the murders was played to the jury. Watch this.
You left him there. You hit him in the head. He's unconscious, not moving.
But there wasn't this much blood. Where I left, he wasn't bleeding like that.
No, this is because it emptied out after you cut his head off.
I didn't cut his head off.
Oh, you did.
No, I didn't.
And you did. Explain how this happened.
I don't know. I can't cut a person's head off.
You would agree with me that when you sat down and you began your interview, you were convinced that she had committed the crime.
Correct.
So you'd agree with me that you went in there not necessarily with a motive to find out information, but to get her to confess to the crime, correct?
We were trying to confront her on the evidence that we had that she was not admitting to.
Yesterday, again, that's how the case ended for the state's case in chief. The testimony is set to resume today at 2 p.m. Eastern, and then we're going to find out if the defense plans to call any witnesses, but it really seems likely the way that they've been cross-examining a lot of these witnesses.
I mean, they pointed the finger at the boy, her husband, the decedent's son. What's your gut tell you on her, the porn star taking the stand?
Well, you know, looking at these defense attorneys, the last client that we covered here at Court TV, the client took the stand. That was Robert Tellez. So we think that she's going to take the stand. Here's why. The defense has been pointing the finger at the victim's son, who is also the defendant's husband, as the real killer. And during a sentencing hearing, she burst in court. She was crying. She made a huge statement to the judge saying that she wants to prove her innocence. Take a listen.
I know right now no one in the family feels that I'm innocent at any point, and I understand that, but I can actually prove my innocence. I actually can, and I'm not going to stop fighting to prove my innocence.
She's not going to stop fighting. She wants to tell her story. We're going to find out today, Ted, if in fact she's going to testify, if in fact they call other witnesses. It's going to be a must-see day in this trial.
Yeah, best way to tell your story is get on the stand. The worst way to, or the fastest way to go to prison is to get on the stand. We'll see what the former porn star
yesterday,
does.
the testimony
Dima's.
from,
Yeah, Matt, thank you. We'll continue to watch what's going on in Vegas once they're up and running. Meanwhile, let's head to Florida. See what the attorney for Dima Tower is going to do to try to get some of these jurors to at least contemplate manslaughter instead of murder. Let's go in for the defense close.
Like we talked about at the beginning of this case, Mr. Tower's words still hold truth. It has a lot to do with everything that I've been through and everything that I've seen. And you've heard a lot of evidence in this case, and frankly, a lot of it was not disputed. The facts and circumstances of the tragic events of August the 31st of 2023 are not materially in dispute. Robbie Tower is deceased. Jennifer Tower is deceased. Those things occurred because of acts by Dima Tower. That is not in dispute. What is in dispute is whether or not Dima Tower had the rational, conscious intent to commit the homicides prior to them occurring. That is what is in dispute in this case, and that is what we have been asking you to focus on and not get sidetracked into different areas. The judge has instructed you that you have to presume Mr. Tower to be innocent before you start. We kind of dialed that back a little bit and said, look, before we even start this trial, I want to make sure that we're clear about what we're asking of you. And what we're asking of you is to make a decision about one simple thing. And it may not seem that simple, and it may seem very complicated to get inside the head of somebody else. And it is. It's complicated. The state has the burden of proving these crimes beyond and to the exclusion of every reasonable doubt. I know the state will say that most of what we've been talking about is trying to invoke sympathy for Mr. Tower. That is not the case. It is important, if you're making a decision about somebody's state of mind, that you are exposed to them so that you can make an informed decision. There's a lot of talk in the jury instructions about people of ordinary judgment making decisions. And what the judge has instructed you is that it's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should be relied on in considering your verdict. We talked during jury selection about the fact that you don't leave your personal life experiences at the door. You bring those in because they form your common sense. And you can make the determination as to whether or not it's significant that Mr. Tower couldn't look me in the eye, couldn't look the state attorney in the eye, couldn't look the detectives in the eye at any point in time. That is something that is common for certain people. And when we're talking about individualized consciousness of guilt, every individual reflects differently. Every individual thinks differently. So if we're talking about the fixed time for reflective thought, it's important to consider all of the factors as to whether or not Mr. Tower had sufficient time for him to make reflective thought. Given his history, whether or not the killing was done after consciously deciding to do it. I would submit that Mr. Tower doesn't have the ability.
I'm going to object to this, and may we approach?
No, I'm going to sustain the objection.
Okay.
Sustain the objection.
Thank you.
I'll disregard the last statement by defense counsel.
The question of premeditation is a question of fact to be determined by you from the evidence. And the judge instructs you, again, use your common sense. Think about what evidence is reliable and what evidence isn't reliable. As Mr. Tower indicated, when there was discussions with law enforcement, he was concerned that there were misstatements, misunderstandings, which would be something you would understand from somebody who was in foster care in a foreign country, who didn't know the language before he got here, who learned the language himself by small talk, who was obviously awkward and uncomfortable. You can make a determination as far as all of those things, as to what weight you put on each piece of evidence and what weight you assign. Because like we talked about from the beginning, each of you individually has a verdict. And collectively, as a jury, you make a decision. But it is important for each and every one of you to have your voices heard. It's important that you take time to deliberate and make a determination as far as what culpability Mr. Tower has. I would suggest to you that the evidence presented leads to a manslaughter conviction. And we would ask that you come back with that verdict. Thank you.
All right, Marc Gilman, delivering the close, doing the best he can. Pretty good close there, considering the facts. Let's get a break. We're in verdict watch in 2 cases, Iowa, Florida. Busy Friday, might beat Vegas later today, too. Stay with us.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
to Florida we go. State's rebuttal. Let's watch.
Defense counsel argued that defendant told you yesterday, and he did, that this has a lot to do with everything I've been through and everything I've seen. You've heard no evidence, zero evidence of the defendant and what he saw and what he's been through. You are not.
Burden shifting?
I'll overrule the objection. I'll just remind everybody, there's no obligation or burden on the defense to do anything. You may continue.
The defense has no burden. But when you hear arguments that defy logic, you can reject the arguments by the defense. The defendant doesn't have to prove anything in this case, but he did. He proved everything in this case when he took that stand yesterday, and he said, I was sitting in the car thinking about it before I went into the house. I thought about killing my parents before I went into the house. So again, does the defense have to prove anything? No. Is it my burden? Yes. And I urge you to hold the state to its burden. But you have heard no evidence, absolutely no evidence, about what the defendant has seen and what the defendant has been through. And that is not burden shifting. That is simply a fact. The defendant described this as rage, but not rage that developed suddenly from a sudden event, some altercation with his parents, something that would make an ordinary, reasonable person lose self-control. This wasn't something sudden that happened that made Dima Tower lose his normal self-control and go in there and stab his parents. As I said earlier, his parents were fast asleep in their bed. They posed absolutely no danger to him. They did nothing to upset him or provoke his rage that night. I don't know where his rage was fostered, and neither do you. But he had rage for his parents when he was sitting out in that car, and he acted on that rage. This was not manslaughter. This was not a crime of passion. He sat out in his car and thought about it. And again, you're going to hear instructions about speculation. They're in your jury instructions. On Monday night, you took an oath to well and truly try this case based on the law and based on the facts, not on speculation. In fact, the jury instructions forbid you to speculate about the defendant's past or what he's seen or what he went through when his mother died. That's pure speculation, and you may not do that. Do not let yourself be persuaded because the defendant tried to and was prevented, correctly so, from talking about his past, because that is not why we're here. We're here because the defendant killed his parents. The law doesn't change for people to fit their situations. Whether you're an executive of Coca-Cola or whether you're a kid from a bad neighborhood, whether you graduated from Northport High School or you graduated from Harvard, the law is the same for every single person. And what he went through when he was a kid has nothing to do with this crime that he committed. Don't be persuaded that because the defendant had a horrible childhood and he ended up in an orphanage, that he's somehow justified in doing what he did. Those photographs say everything. There is no justification for that. I'm asking you to think about the facts and think about the law, and only that, because there is no room for sympathy or speculation in your job. I'm asking you to hold the defendant accountable for what he did. I'm asking you to find him guilty of killing Robbie Tower and Jennifer Tower after premeditation. I'm asking you to hold him guilty of first-degree murder on both counts, and also for fleeing to elude law enforcement officer with lights and siren. I thank you for your patience and your attention.
All right, that concludes the closing arguments. Folks, as you might know, I think we talked about this at jury selection. We chose to have 2 alternates because we were going for the whole week. If someone got sick, we would have them fill in. Do you folks remember your numbers from day one? Remember you had a paddle in your hand? I'm going to try to see if we can identify our alternates.
All right, and that is it. The final words to the jury. We're in jury watch in 2 trials, plus Vegas. Busy Friday. Stay with us. Back after this.
affordable for Medicare patients than Dexcom G7. Don't wait. Call now and talk to a real person.
This is Court TV Live. I'm Kelly Craft in today for Ted Rollins. Thank you for being with us and happy Friday, everyone. We are in Florida this morning and we are now in a verdict watch in the adopted son murder trial. On the night of August 31st, 2023, a neighbor woke up to screams and a blood trail leading to her next door neighbor's home. Police later arrived to find Jennifer and Robbie Tower stabbed to death in their home and their adopted son, Dima Tower, fleeing in a car. When the then 21-year-old was eventually apprehended, he admitted to police that he had stabbed his parents. But the defense is saying this was in a moment of rage and should be considered manslaughter, not first-degree murder. The jury has just gotten this case there in Florida, so this hour we want to look back at defendant Dima Tower's testimony. This took place yesterday. It was contentious at times, also emotional. So let's go in now for the start of his direct examination.
How old were you when your mother passed away?
Well, my mother passed away. You know, I would like to talk about, before I would start about talking about my life before my mother passed away.
I understand that. The issue that is that I'm hoping that you can respond to the questions.
Yeah, I can respond to the questions,
Sure.
but.
Okay, so your mother, how old were you when your mother passed away?
I'm somewhere between 6, 7, or 8.
Okay,
I was thinking about this somewhere between those years.
Okay.
I mean, if maybe I can give a little bit of my personal background or something.
Mr. Tower, the way it's going to work the same with all witnesses. You need to listen to the question and then answer only the question that's been asked of you, okay?
Well, it's important that.
It may be important, but you need to follow the rules in a courtroom, okay? Please ask your next question.
Sure. Were you just living only with your mom when she passed?
Yes.
Okay.
I was.
And then who did you go to live with after that?
I went to live with my brother.
Okay. How long did that last for?
Maybe a couple months, so.
Okay. And then where did you go?
I went to my uncle's house.
Okay. How long did that last for?
A couple months.
And you eventually end up in the foster care system in Ukraine, correct?
Objection, leading.
Yeah, I was in 2 orphanage for foster care, orphanages, whatever they call that. The first one I was in before the war, and then
Objection,
I was.
responsive.
Overruled. I think he's trying to give a time frame of when he was in the orphanage. You can answer the question.
I was in the first orphanage in that same region I was born in, the same side of Ukraine. And then when the war started, we were moved to another part of Ukraine, which is somewhere close to the sea.
And was it around that time that you met the Towers, that they came over to meet you?
Yes, I met them at I believe it was end of summer of 2013. I met him. Well, I actually met him over here after I was sent to visit for a month in the States. I flew in and met him at the airport.
Was that the first time that you had met them?
That was for the first time, yes.
Okay. And how long after that do you come to this country?
Well, I also came for the second visit. The summer of 2014, I came for the second visit to meet the rest of the family.
And then you come to live permanently when? In 2015?
Well, I was adopted right before the 2015. I was adopted that winter, and I came to live here in 2015. Yes.
Okay. Did you go to school here in Sarasota County?
The questions that you're asking me are very complicated, and cannot be simply answered. But I'm forced to simply answer the questions, which cannot, for no right reason, can be answered simply. These are not simple questions.
Your Honor, I object to the editorializing by this witness. Other witnesses are not allowed to have this kind of conversation with counsel.
Let's try not to have speaking objections, Counselor. I'll sustain the objection as non-responsive. Please move on, Mr. Gilman.
Do you remember talking to law enforcement in this case and telling them that you went to Northport High School for a little while?
Yeah, I went to, right after I was adopted, I went to the school in Northport, Woodland Middle School. And then after I did a half a year in that, I enrolled in Northport High School.
Okay.
Which I dropped out of in 10th grade.
Okay. And did you know any English before you came to the United States?
No.
How did you learn English?
By conversating here and there, small talk.
All right. And how long did you live with the Towers prior to, either graduating high school or moving out?
Again, this is a complicated question, and
Objection to narrative.
the answer, it can be very long because I moved in, I moved out.
Objection to narrative.
I'm going to sustain the objection as non-responsive.
Okay. You say you dropped out after 10th grade. Did you move out after that?
No, I stayed, but I didn't really move out on my own. It's just too many family issues.
Okay. And you were not living with them. When did you move back in with them prior to August the 31st of 2023?
I don't understand the question.
So in August of 2023, which is the incident that we're talking about, how long prior to that were you back living with the house? Because I know you had just moved back there, correct?
Well, yeah, I assumed that
Do you need a moment, Mr. Tower?
Ask for the.
Remember the jurors, let's take a break. Please leave your notepads face down, writing implements on top. Please don't discuss anything related to your jury. Everybody stand, jurors exiting.
We were listening to the direct examination of Dima Tower. At that point in time, the judge sent the jury out of the room, and so finding out if the defendant could end up continuing with his testimony, eventually he did. So that's a replay, because you can see at the bottom of your screen, we aren't in a verdict watch in that case. The jury does have it. They are only a few minutes in, 43 minutes to be exact. We also have another verdict clock up there now. That's in the Truesdell case in Iowa. But let's bring in our guest to talk about what we were just seeing from the defendant on the stand. Joining us now from Fort Lauderdale, Florida, criminal defense attorney Michael Gottlieb. Michael, thank you so much for being with us on this Friday. We're replaying some of that testimony from the defendant when he took the stand yesterday. What did you make of his testimony? That was on direct that we were replaying.
Well, number one, it's always dangerous for a defendant to testify.
You know, juries get perceptions of the defendant from the moment they walk into the courtroom. Number two, he was testifying against the advice of his counsel. But he also seems, I think, somewhat sympathetic, somewhat pathetic. He's trying for some kind of loose insanity defense, saying that he was insane at the time. You know, this is a tough case. This is an individual who, you know, was born in Ukraine, subjected to all kinds of horrors, adopted at the age of 14, 15, and then murdered his adoptive parents, which is, you know, incredibly sympathetic to a jury on the side of the parents. So I think he's taking a calculated risk. The fact that he's breaking down may inure to his benefit to get a lesser included verdict instead of the murder in the first degree.
Michael, when you talk about that insanity situation, we did hear him on the stand saying to the prosecutor in this case that I was temporarily insane, even when, not only when I was killing my parents, but also during the police interviews, that I was not in my right mind. Now, the judge did tell the jury to disregard that, because this is not a situation of I'm pleading guilty or not guilty by reason of insanity. So disregard any insanity reference. What did you make of that?
So you know, there is a concept that you can have a jury pardon. So the jury may disregard it, they may not. You can't unring a bell once it's been rung. Some jurors are going to stick to the black letter of the law and follow what the judge tells them. Others are going to say, look, he clearly exhibited signs of insanity. They can determine on their own. You know, that's why we don't invade the province of the jurors when they deliberate. They can determine on their own whether or not that's a sufficient mitigating factor in terms of his guilt or not, his temporary insanity. Most states have a defense of temporary insanity, which is not a bar to prosecution, but you could be found not guilty by reason of insanity and typically committed to a Department of Children and Families you could be sentenced to the rest of your life in confinement. Think of John Hinckley, who was, you know, incarcerated mentally. But the judge telling him to ignore it, who knows what the jury's going to do in this case. Some will, some won't.
And talking about things to ignore, the prosecutor was very clear with the jury when she delivered her closing argument, saying, I am instructing you, the jury, the law instructs you to not take into account his past, what he was wanting to talk about on the stand, about what happened between him and his mother after his mother died, how he was treated. She was very clear with them, you are not supposed to take that into account. What did you think of that approach?
Well, I think it's interesting, and what it means is, to me, having tried hundreds of cases, it means that rung a bell with the prosecutor, right? She's acutely aware of how significant that testimony may be, that jurors have sympathy. We're all human beings. And, you know, despite the fact that this is a heinous, atrocious crime, jurors have sympathy for somebody who is so pathetic. And here you have an individual crying, saying, I was insane, saying I had a horrible childhood. These aren't my parents. So, you know, I think it still weighs in the minds of some jurors, and despite everything we do when we pick a jury to try to get them to focus on the evidence as the judge instructs them, there are going to be jurors who are going to run rogue and who are going to make a decision based on other factors that they see, sympathy being one of them.
Yeah, absolutely. Good point, Michael. Okay, we're going to squeeze in a break, and when we come back, we'll have more of Tower's direct examination. Stay with us. You're watching Court TV Live, your front row seat to justice.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help party, I'm dying.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Where was your mom at? Right there. She was next to him? Did she wake up? Yep. So, you do know that, like, we're trying to piece this together, okay? So, your dad starts getting up out of bed? No, he wasn't. He was sleeping. Okay. And you stabbed him? Yep. Do you remember how many times? Countless. I'm sorry? Countless.
That was defendant Dima Tower there, admitting to police that he fatally stabbed his adoptive parents countless times. This was back in August of 2023. But the defense isn't denying that Tower killed Jennifer and Robbie Tower. They say it was done in a moment of rage and should be considered manslaughter, not first-degree murder. The jury has been deliberating now for nearly an hour, so we're at 53 minutes there in that case we're watching in Florida. So while we wait, we're going to look back at Dima Tower's testimony. Let's go back in for more of his direct examination.
Please.
Right. And Mr. Tower, I want to focus you on when you sat down and talked with the police down there in Venice. Do you remember that?
I do.
Okay. Was that the first time that you had ever had that kind of encounter with police?
Yes.
How'd that make you feel?
Objection.
Awkward. Made me feel awkward.
Hold on.
Hold on, one moment. I'll overrule the objection.
Okay, why would you say it makes you feel awkward?
Because I'm uncomfortable talking because I had many miscommunication and or not enough communication or misunderstanding with my adopted parents. So I grew up into not knowing how to talk.
Objection, non-responsive.
Overruled. It was completing the answer. You may continue, Mr. Gilman.
So when you were talking with the police, did you understand everything that they were asking you?
I did.
Did you feel like you answered appropriately given that you were uncomfortable?
No.
Okay. Do you remember talking with them about multiple times having thoughts of killing your parents?
Yeah, I only had those thoughts a couple times.
Okay. Did you ever have a plan in place to make that happen?
No, I did not.
Okay. I don't think I have anything further, Judge.
State cross-examination, you ready?
Are you going to look me in the eye, Mr. Tower? That's not. So you said you didn't think about killing your parents.
I did not plan on it.
Mr. Tower.
It was not premeditated.
Mr. Tower, when I ask you a question, you can answer, but not until then. You pulled out a sharp knife and you walked into your parents' bedroom, didn't you?
Yes.
Okay. What were you thinking about between the time you took that sharp knife, walked into your parents' bedroom, and started to stab your father in the dark?
I wasn't thinking anything.
You weren't thinking anything.
What is there to think?
I don't know. Your parents were sound asleep, weren't they?
I don't know.
Was your father awake when you started to stab him?
It was pitch black.
You picked up a knife from the kitchen and you cowardly went into
Objection,
your,
argumentative. Sustained.
were your parents awake?
I don't know if they were awake. I already answered it.
Sustained.
You asked me a second time.
What did you say?
You asked me a second time the same question.
What did your father say after you stabbed him?
What the hell are you doing?
And then what happened? Did you stab him again?
Yes.
Okay, what were you thinking about between the first stab and the second stab?
There's nothing to think.
Nothing to think.
What am I supposed to think, Dad?
Listen to me, there was nothing to think, that's your answer, all right. So, you're telling me that as a human being, you walked into your father's bedroom with your mother sleeping next to him. The parents that brought you over here.
Objection, argumentative, compound question.
These people were not my parents.
Hold on. I'm going to overrule the objection. It's a bit compoundish, but I'm going to allow it. You may continue with your question.
Thank you. The parents that brought you over here to this country, and you weren't thinking anything.
These people were not my parents. There's a lot went on that changed our relationship.
That's not my question. My question is, are you telling this jury that you won't even look in the eye that the people who brought you over here and gave you a home, that you were stabbing them and you didn't think anything of it? Is that what you're saying?
The answer's too complicated for you.
No, it's not a complicated answer. It's a yes or it's a no.
It's not. It's a complicated answer.
Tower, you told the detectives that you were a nobody from nowhere, didn't you?
When I was talking to detectives, I was not in my completely right state of mind.
Mr. Tower, did you tell the detectives that you were a nobody from nowhere?
I just answered your question.
No, you didn't.
I said I was not in my right state of mind when I was talking to detectives. It just went on a lot, you know.
Let the jury recall what they heard.
Objection, argumentative.
I was under the influence of alcohol also.
I'll sustain that it's unresponsive. He's not answering your question.
Your parents.
They were not my parents, unfortunately.
Sir, you cannot interrupt the attorney. Wait for them to finish their question, and then you can answer the question asked of you, okay? Please ask your question.
Mr. Tower, the people that brought you over here, they gave you an opportunity to be a somebody from somewhere, didn't they?
It depends on their parenting.
What?
It depends on their parenting, how you raise your children.
Depends on the what?
You don't even know what I'm talking about.
No,
Have you ever been a mother of children?
After you stabbed your father to death, you walked outside with a knife in your hand because Jennifer was outdoors, wasn't she?
I was temporarily insane.
Sir, can you please sit back from the microphone? It's difficult to hear you. Thank you.
All right. When you walked out of the house after you killed your father, did you carry the knife with you to lead Jennifer back in?
I did.
You did or did not?
Okay, we were listening to the replay of that cross-examination from the prosecutor as we listened to Dima Tower on the stand. Let's go ahead and bring in criminal defense attorney Michael Gottlieb. As we have those verdict clocks up in the Florida case, over 1 hour they have been deliberating so far. Michael, what is your takeaway from that cross-examination and the prosecutor and some of the things that she said in the beginning when she was asking him to look at her? Are you going to look me in the eye? She even said that in one of her comments. She said, you're not even looking the jury in the eye.
Yeah, I mean, that's not, I don't feel that that's significant at all. I don't think it's proving any points. I think if anything, it shows
either he's remorseful or maybe he doesn't have, or he does have some kind of significant mental health problems. I don't think she's winning points on this cross-examination. I don't think starting out that way endears her to the jury. This is an individual who seemingly has a mental health problem. He looks at in terms of his attitude and demeanor and his affect while he's in court. But I think more importantly, she's opened the door to his mental health by asking him, what were you thinking at the time? And I think he's really doing pretty well in basically saying, I wasn't thinking, I was insane at the time. And then he goes further to explain, these weren't my parents. You don't know how they treated me. Have you ever been a mother? That's planting questions in the minds of the jury. Is this an individual who was subject to abuse? Has he been abused? Was he acting in rage? Because these were people who took advantage of him. And I think that those are questions, at least at this point in time, that remain unanswered by this cross-examination.
Yeah, some of the other things that we heard with him on the stand was they had adopted him from the Ukraine, but yet the father didn't want a boy. He had preferred a girl. He actually wasn't even that interested in adoption in the first place. So he was able to get a lot of information out on cross, and then even going as far as saying, well, he didn't even love Jennifer, talking about the father loving his wife. So he got a lot of information out, and you could tell he was getting under the prosecutor's skin.
Oh, yeah. First of all, prosecutors are more accustomed to doing direct examinations. Not that they don't do cross-examinations, but it's very rare for a defendant to testify in a criminal case. And again, him testifying here was against the advice of his counsel, so they may not have had any notice whatsoever. And it kind of feels like typically when you do a cross-examination, you want to ask a question that you know the answer to, not a question that you don't know the answer to, and not an open-ended question. And there's a lot of fishing that seems to be going on. If I were to do the cross-examination, I would just go through his confession. You said this, you said this, you said this, and then shut it down. I think that by giving him the opportunity to talk, they're really hurting their case.
Yeah, and then, you know, we did hear him eventually say on the cross-examination, she was getting him to eventually admit that he had thought about this moments before when maybe he was in the car and maybe one other time. She did get him to say that, and so you have defense counsel here asking the jury for manslaughter. When he said that, I mean, that does say premeditation.
Yeah, so that's the interesting thing about premeditation. It can be seconds before a crime. It can be days, weeks, or months before a crime. So the fact that he's thought about it in the past, the fact that he thought about it right before he did it, may plant in the minds of the jurors that, yes, this is premeditated first-degree murder, and that's what we should convict him of.
Yeah. We'll continue to follow it, Michael. Thank you. We're going to squeeze in a break. More from this case and many others when we come back. You're watching Court TV Live, your front row seat to justice.
Oh.
You're watching Court TV. I'm Kelly Craft in today for Ted Rollins. Thank you for being with us. We're going to turn now to Massachusetts, where Brian Walsh is back in court today for a competency hearing. Walsh was set to go to trial for the murder of his wife last month, but his trial was delayed after a judge ordered Walsh to undergo a mental health evaluation. Prosecutors allege Walsh murdered and dismembered his wife, Anna, on New Year's Day in 2023. Her body has never been found. Before we get you back into the courtroom there or into court, here's Court TV crime and justice correspondent Matt Johnson with more on this case against Brian Walsh.
No comment from Brian Walsh after he was charged with the murder of his wife, Anna Walsh, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walsh was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walsh told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Cap saw best tool to dismember. At 1:10 p.m., can you be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walsh came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walsh drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walsh drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walsh property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walsh was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walsh, as well as disinterring of a body.
Let's go into court now for the start of that hearing.
Welcome, as I said, to counsel, and welcome to Mr. Walsh. I have a few things on my agenda. The first one, which is why we're here, is the competency. I've now received a report from Bridgewater State Hospital, a comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial. And with that finding, which I accept, I had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
Two things here. One, we're not contesting the competency finding. Two, we've had conferences with Dr. Ryan. We had them last night. What he asked us to do, is he is concerned that changing the letter to the jail may have an adverse effect on this report. He wants us to advise us, ask us to come on board with his concern about that. He said that's not his lane, but we want to let the court know that we have this concern, and might be posing a problem, or also inform the jail and get ready for that. But other than that, we're not contesting contest.
All right. As with any case, and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and you and alerting the facility knows this. They deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time. I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial. So hopefully that'll give him a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me.
Thank you.
All right. So, let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire, which I will incorporate into the next version of the draft questionnaire. It's always a draft until the minute that I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers. Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day, and there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the impanelment on Tuesday. So it looks like 105, 126, 121, 68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling on Monday and Tuesday. Our intent is, if we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, the Monday after the Thanksgiving holiday.
All right, we are watching that competency hearing that's taking place in Massachusetts. We are gearing up for this trial. This is going to be Court TV's next biggest trial that we're going to cover here. What the judge is deciding right now is if Brian Walsh is fit to go to trial for murdering his wife. Let's go ahead and bring in criminal defense attorney Michael Gottlieb to talk about what we were hearing there. This is a competency hearing, Michael. Kind of talk about why that's taking place in the first place.
So a defendant cannot be brought to trial unless a defendant is competent to proceed, meaning they have to understand the roles of all the actors, the judge, what the judge's role is, what the prosecutor's role is, what the defense attorney's role is. They have to have an ability to assist, to behave in court, to testify relevantly, and it seems like he was sent away for evaluation. He was gone for 40 days. The judge has made a determination based on the report that he's competent, and it doesn't sound like the defense team took issue with that, only they wanted him to get reacclimated to the new prison setting that he is in. And now the judge is setting the trial schedule.
In regard to jurors, so jury selection is going to begin next week. From a defense counsel's standpoint, Michael, who would you be looking for to sit on the jury?
So, you know, that's an interesting question. When we pick juries, we play amateur psychologist in terms of trying to figure out who's going to be the right person to be selected. I wouldn't want anybody who's been divorced. This is a situation where, you know, obviously there was some kind of strife. They found evidence of the murder in the house. They found him doing things. There's circumstantial evidence. So you're going to want people perhaps that are very analytical, who are going to want more than circumstantial evidence, people who haven't been in a bad relationship, people who are going to want strong scientific evidence, DNA, blood evidence, maybe stronger than what the government seems to have in a case like this. But it's always very difficult to know where people are going to land. Very hard to pick juries and decide who you want before you have the opportunity to speak with them and really know what they bring to the table.
Yeah. Yeah, good point there. Yeah, the jury selection is going to begin next week. I believe she said she's going to start bringing in 60 to 70 people. So, of course, we're going to follow that and bring our viewers up to date on all the developments in that case that will be taking place in Massachusetts. Michael, thank you. We're going to squeeze in a quick break, getting close to 12 o'clock. But you can see we have 2 jury clocks up right now, one in Truesdale that's taking place in Cedar Rapids, Iowa, the other in the Florida v. Tower case. We'll squeeze in a break. We'll be right back.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
Back now to Massachusetts, where Brian Walsh has just been cleared to go forward with his murder trial. Walsh is charged with first-degree murder in the presumed death of his wife, Anna, who was last seen on January 1st of 2023. The trial was initially delayed after a judge ordered Walsh to undergo a mental health evaluation, but he has now been cleared. Let's go in now for more of that hearing.
Thanksgiving holiday. Everybody on board with that schedule? All right, good. Let me next address, and then once I do this, I'll certainly turn it over to you. We're going to have a formal, really today's purpose was to address the competency, but to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now. Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walsh was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even even pervasive adverse publicity does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass 130 at 141, and Commonwealth versus Tulin, 460 Mass at 452, at pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage. And, quote, the entire venire may be presumed prejudiced regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind.
Coming up, we're going to have more from the competency hearing for Brian Walsh. And also, you will notice that verdict clock in Florida v. Tower has stopped. We have a verdict in that case. We'll take you there when we come back.
seated, everyone. Good afternoon. 2 more minutes, I guess. All right, Deputy, I'm told we have a verdict. Is that right?
Yes, Your Honor.
All right, we have everybody present. Are both sides ready to bring the jurors back in?
Yes, Your Honor.
Yes, Your Honor.
All right, let me just caution everybody in the audience, we're going to respect the verdict, whatever it is, by this jury. So please, similar to what we talked about earlier, no outward signs of emotion or comments. We need to be professional, respect the jury. So if you can't handle it, then I need you to remove yourself kindly, okay? All right, let's bring the jurors in.
All rise, jury is entering.
All right, welcome back, everybody. Everybody may be seated. Members of the jury, I'm told that you reached a verdict. Is that correct?
Yes.
Can the foreperson hand it to the bailiff? I take a look at it next to make sure that it's executed, signed, and dated, etc. And then I'll hand it to the clerk. Can you please hand this to the clerk? And the clerk is going to publish the verdict.
In the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida, State of Florida versus Dima Tower, case number 2023 CF 8812NC. Verdict. We, the jury, find as follows as to count 1, victim Jennifer Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 2, victim Robbie Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 3. The defendant is guilty of fleeing to elude a law enforcement officer as charged. So say we all this 14th day of November 2025, signed foreperson.
Members of the jury, there's something we do after every verdict. It's called polling the jury. So what I'm going to do is I'm going to start in the back. I'll go left to right, then I'll come forward and go left to right, okay? So to the gentleman in the back left, is this your verdict and the verdict of the jury as a whole?
Yes.
To the gentleman next door, is this your verdict and the verdict of the jury as the whole?
Yes.
Ma'am, is this your verdict and the verdict of the jury as a whole?
Yes.
Ma'am, is this your verdict and the verdict of the jury as a whole?
Yes.
Young lady on the far right, is this your verdict and the verdict of the jury as a whole? To the gentleman in front, is this your verdict?
Yes.
Next gentleman, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
And ma'am, is this your verdict? Folks, on behalf of everybody, I want to thank you for your service. We have different types of trials. This was a longer trial, although as I mentioned, not terribly long. We do have those that are longer. We asked a lot of you. You came in Monday on a week with a holiday. You were here all week, early in the morning. So we all truly appreciate your service. The system cannot function without you folks, and I talked a lot about that on Monday, so thank you. You have a right as a juror not to discuss your jury service with anybody. That's a right you have as a juror. It would take a court order to compel it. I haven't seen it in my career done. You also have the ability to speak to whoever you want. That's a right you have as a juror as well. No one can prevent you from speaking. I know it's a big ask, again, Monday through Friday. I hope the experience was good for you. We try to be as efficient as possible with your time and not get you in and out as efficiently as possible. So again, thank you. Your service is done. What I'm going to do after you leave is I'm going to talk to the parties. We'll discuss setting a sentencing date. I don't know if we're going to do that today or if we're going to do it down the road. You're welcome to stay. You're welcome to leave. You have no further obligation to the court. I think it gets you out of jury service for a year, so there's some good news. But again, thank you. Make sure you take all your personal belongings with you when you leave. If you want to find out what happened or what happens, you can give my judicial assistant a call, Jennifer. Her number's on the board, I believe, in your jury room. You can give her a call later today and find out what the next steps are, okay? Thank you so much, everybody, for your service. Can everybody please stand? Our jurors are now exiting the courtroom. All right, let's take I'm going to take a 2-minute break. I'm going to go thank the jurors for their service in the jury room. Why don't let's leave Mr. Let's handcuff him. Let's leave him in here for now. Why don't you talk among yourselves when you want to do sentencing, how you want that to take place. I'd also like the attorneys to please approach and take a look at the verdict form before it's filed, okay? I'll be back in a couple of minutes.